Mention item number 49, my lord. That order has.
In item number 49, counsel
Respondent
appearing
number
for
2.
respondent number 2, and for one contempt petition has been filed, has already been petition stands dismissed.
Item number 11, filing the wakalatnama.
You are going to appear for submits that they have been newly engaged in due course today. Stop. Who's appearing for respondents? Government?
The
Yes, my lord. Tomorrow the analogous matters are fixed there.
21 and 22
Just one
for
second.
adjournment and 22 with the consent of the other party. My senior visit Mena.
Mr. A. Mena, which is not opposed by the other side. Yes.
May I please? I need to file an affidavit.
Wait for your turn.
Yes, Lord.
Before appropriate bench.
Of Mr. G. Chaudhary. Yes, sir. On behalf of G. Chaudhary.
You are for after 2 weeks. 2 weeks on a date to be fixed by the registry. Matter. Next.
Yes, lordship.
Is unwell today. List this which is not.
Please, Your Lordship. I get to after 3 weeks time, my lord, private respondent
You are filing a reply.
no petitioner.
And you want time for what? Yes. Next.
Last day this matter was fixed for.
It's an admission matter.
May it please your lordship.
The list on. Next.
Because lordship is an analogous case.
Yes.
Cross cases they are, my lord, both the case diary, my lord, kindly, my lord.
Item 4. You are for.
They will taking want to file reply, so adjournment.
Learned counsel for the petitioner who is of the stay order on 22/4/2020.
Submitted the proposal in 9/5/2020.
It is submitted at bar that the petitioner has been asked this matter after 4 weeks on a date to be fixed by the registry. I am keeping it after.
Please, Your Lordship. Lordship,
Filed by the enclosing the electrical inspector's report.
By Mr.
B. Chaudhary,
B. Chaudhary, learned stop. Let a copy be let by the registry.
Deeply.
Have you filed?
No, Lordship, because I could not
2022. The learned counsel for the petitioner
time, Lordship.
for
filing the
letter has been sent to her client. She has not received any. You make an effort, otherwise list after 2 weeks on a day. Yes, who's appearing? Please ask him to be here. It's a 2017 matter. Regard status of the formal proposal of settlement
10 lakhs. So these are the instructions. So may I?
and seeks time to place the same by way of an affidavit. Stop. The prayer is not opposed by the petition.
On the 13th, as part order dated 13th, so my lord, maybe fix after due vacation, my lord, so that I can.
It is called for is not available with the government council. Stop. List this matter as directed by order dated 13/3/2020.
Yes.
Who is appearing? Revenue.
Will be applicable.
Which the new.
2019.
19 police.
You will not get a chance.
Since, my lord, but this is prevailing, my lord, after 2019.
Case 49, my lord. To the Deputy Commissioner Dubri. Finally, my lord, before the my lord, Secretary, Governor of Assam, since no response was given by the.
So your grievance is that since you have applied for the settlement allotment and since no action has been taken till date, on that you had approached the this petition. So you are, if this court disposes of this petition with a direction in item number 12. Heard Mr. M.U. Mondal, learned counsel for the petitioner. Stop. Also heard Mr. A. Borwa.
A. Bhattacharya.
A. Bhattacharya, learned standing counsel revenue.
Correspondent number 1, he is appealing.
1,
Remaining
3, 4, 5 and 6.
7.
Stop.
7 only.
7? Yes. 7. This is an application under Article 226 wherein the petitioner is canvassing the inaction of the respondent authorities 02 at village Bilasipara, Sadar, bounds by East Subhash Saha, West Government Land, Bri, Assam. This you will find in page 9. Stop. The petitioners measuring as stated constructed a settle nut shop by paying is the further case of the petitioner that he has applied for settlement stroke allotment of the said plot of land by various applications which are annexed as Annexure 7.
7, 8 and 9.
Annexure 7 has not been. Mr. A. Bhattacharya, Government 19. Consent of the subject land has not been considered by these to
Respondent number 3.
in receipt of the
Application before the Deputy Commissioner.
then on number
3.
3 I Deputy Commissioner same in accordance with law.
Last year, my lord, and this has come after long. Here, what has happened is, my lord, the FF, and that is to be done by the.
No instructions from DC.
I've been asked to take instructions
Yes, they have
on
sought
documents as
yes,
required.
What is the status
So
of
I have to take.
this call? Stop, Mr. To the effect that budget shall be distributed for preparing FS proposal towards payment of the pending dues against supply of furniture of budget communication
Portal.
finance Assam
The DC man.
proposal in the available with Mr. by the Government Council on the next and submit appropriate necessary date of the
After the
review.
brief.
For very long, my lord. And it has come up after a lapse of 2 years.
That the petitioner has already taken. However, no alternate. Let the council, let the engaged counsel for the petitioner verify the same and inform the petitioner. Stop. List after 2 weeks and a date to be fixed by the registry. You call up and you find out, and if needed, you file an affidavit saying that the brief has been taken away.
Obliged, ma'am.
Yes, Mr. Dhar.
May I please, Your Lordship? My Lord, this on last occasion by the order dated 9/8/2023, the my friend was asked to bring the records.
On which date the respondent ADC as well as National Highway shall produce the records in respect to the acquisition of the petitioner's land.
My lord, I am for National Highway Authority of India.
Yes, you have the records.
Yeah, because record is regarding acquisition, original records are with this one, Kala, Competent Authority Land Acquisition.
Who is appearing? Mr.
With
Goswami
additional
appearing
deputy.
for producing the records. Unless you, why the records are not here? As directed by order dated 9/8/2023. For don't say as directed. It is. It appears that by order dated 9/8/2023, as well as the National Highway Authority to produce. When the matter was called today, the aforesaid records were not.
Lordship.
24 4, on which date the Government Council shall posit. Yes, Mr. Mondal.
This is my lord.
You are for?
The Corporation Department, Respondent 1 to 5.
You are learned
Standing
council.
Corporation.
The date to be fixed by the registry to enable the Corporation Department to file the affidavit in opposition in the matter. Stop. Which is not opposed by the petitioner. List accordingly.
Item 16.
Your Lordship, the senior counsel is on legs in Aizawl bench, Your Lordship. The matter may be passed over for time being.
Time being. Dr. Saraf will appear through VC.
No, through physical mode, Your Lordship. He's
You said
appearing.
in Aizawl bench?
Yeah, he's appearing in the Aizawl bench through VC.
Oh, okay. All right, we'll call after some time. Yes. All of times. Who is appearing for respondent number 4? A report was supposed to be filed here. It's unfortunate that all matters, counsels for petitioners are absent. The 2019 matter. Mr. Goswami, just send the information for a GMDA council. Earlier, Mr. Pathak had appeared. You can ask one of your junior.
May I please, Lordship? Lordship, engaged counsel is on the way, Lordship. Matter may be taken out of some time.
Have you filed the additional affidavit?
We will to file, Lordship. After verification, this may be fixed, Lordship.
Yes, ma'am.
It appears that the additional affidavit which was required to be filed for showing the age of the father
R. Islam on behalf of M. Ali.
On behalf of 2 weeks?
2 weeks.
For the 2 weeks time may be given to the petitioners to bring
Gayan.
A. Gayan, learned counsel for the respondent. Stop. List this matter after 2 weeks on a date to be fixed by the registry to bring the said additional affidavit on record.
Nice to bless you.
Yes, Mr. Roy. Service.
Service complete, my lord.
Service is completed.
Rajima court order is there.
Even the petitioner personally told him.
Service is complete in R4. But anybody appearing?
No.
It appears from office note dated 21/12/2023 that service in respect of respondent number 4 stands. That is the impleading.
Yes.
So we post it on another date.
My lord, he has no possession. It's an admitted case.
But it has just been issued, so we'll wait for some time. Since no representation, this court deemed appropriate to give another to adjourn the list this matter after 2 weeks on a date to be fixed by the registry. It is made clear that in case there is no representation on the next date, on behalf of respondent number 4, the matter. Who is your senior? Yes. None appears for the petitioner when the matter is called. Excise anyone? Excise anybody? Mr. Goswami, you are appearing for excise?
Lordship.
Mr. N. Goswami, Learned Standing Counsel, Excise Department is present. Stop. You have filed you are for R2.
Lordship, in this case,
You have filed your affidavit in the opposition, right? Since there is no representation on behalf of the petitioner, the interim order passed earlier shall not continue thereafter. Stop. List this matter after?
Lordship,
After 4 weeks on a date to be fixed by the registry.
after 4 weeks.
Item 24.
Yes, what is this matter?
Payment of compensation for acquisition of land for construction of dikes.
For construction of?
Dikes by the Water Resource Department.
Compensation for construction of embankment. Embankment. Yes. Yes, Mr. Counsel, what is your case?
My lord, our land has been acquired and which can be estimated by the ascertained by the page number 46, which is annexure number D. Here the authority are saying that the process of land compensation to be provided to the landowners whose lands were acquired against us going on. But in the reply filed by the
This is that chart, page 46, you are referring to the chart.
Yes, it is a reply by the
The process of land compensation to be provided to the landowners whose lands are required against the project are going on. This is the
reply.
This is the reply.
Yes, sir.
And your grievance is that you have still not received the compensation.
Yes, sir.
That is your grievance. Yes.
My lord, in fact, for raising and strengthening the embankment, my lord, the present scheme was taken up, my lord. Accordingly, it's a scheme, my lord, executed way back in the year 1960, my lord. There is no, my lord, record to submit before lordship that at any point of time the land was acquired, my lord.
So there is no materials
Yes.
before the authorities to show that the lands of the petitioners have been acquired.
In the year 1960. Because it's a scheme of, it's
Then
a
Mr.
embankment.
Goswami, you see that page 46, have you seen page
No,
46?
that executive engineer has submitted. He has no right. Because,
What I'm saying
yes,
is that then an order can be passed to that effect.
my lord.
Because you see at page 46 it is mentioned the process of land compensation to be provided to the landowners whose lands are acquired against the projects are going on. Now if that is so, you make a verification and and you pass an order. If there is no land acquired, where is the question of giving compensation? Yes, Ms. Burman, you want to say something?
No, I am assisting him. To that extent, Lordship asked to file us that in respect of para 2, my lord, there are certain land requirements are there, my lord. To that
Even,
extent,
yes.
And accordingly, we filed the affidavit in that stated the various plots of land.
Where is the affidavit?
Yes, affidavit is there, my lord, by the deputy commissioner.
Affidavit, Mr. Goswami, is
Yes, by the respondent number 2.
Respondent 2 filed on 22nd September 23.
Yes. All the land details.
I think requiring authority also filed it. Acquiring authority, requiring.
No, Ms. Burman, you are referring to this particular affidavit of R2.
Yes.
And in fact, my lord, the DAG number and patta number that has been referred in the petition, my lord, all are not
Mr.
correct.
Goswami, you can read para 4
Yes.
of the affidavit.
In regard to the environment, your deponent begs to say there is no record as such available in the office of the deponent towards acquisition of any land as referred to the petitioner for construction of embankment from so-and-so and so-and-so by the Water Resource Department. As per the report of the Executive Engineer, Morigaon Water Resource Division, the area in the region falls in the left bank embankment where raising and strengthening works were taken up under the scheme mentioned above over already existing embankment on the left bank of the river Kopili at Dokhin Dharamtul. It is relevant to state that the embankment in question is partially upon the land bearing DAG number 25 of patta number so-and-so, DAG number 28 of patta number so-and-so, DAG number 193 of patta number so-and-so, DAG number 14 of patta number so-and-so, DAG number 6 of patta number 141 of the Dokhin Dharamtul revenue village of Uttar Kola Mouza under Morigaon Revenue Circle. It is categorically denied the embankment is there over the land bearing DAG number 300 of patta number 200, DAG number 203 of patta number 254, DAG number 34
This
of...
affidavit is very clear.
My lord.
There has been an inquiry also. Sorry, I am reading it fast. I've already reached the next page.
Yes.
Towards the end, it is mentioned after the inquiry by the circle officer.
Yes.
1960. No data record whatsoever relating to any land acquisition process has been found. Then where is the question? Have you filed reply to this?
Yes, we have filed a reply.
What have you stated in your reply? Mr. Goswami, he has a right to reply. What have you stated in your reply?
In paragraph number 4 of the reply,
yes,
that with regards to the paragraph number 4 of the affidavit of filer, Deputy Commissioner Morrigaon, the answering deponent would like to deny the contention and would like to submit the dark numbers and pata numbers of the petitioner itself speaks about the land acquisition, and the same was not denied by the respondent as in his affidavit in opposition.
How will this court go into all this? These are disputed facts in your reply. The fact that there is no data or record, that itself indicates that this land has not been acquired, isn't it?
They are saying that in the year 1960 it has been acquired, but let them make an inquiry.
The scheme was of 1960.
Inquiry has already been done by the circle officer.
My lord,
you see, otherwise this court can always direct an inquiry, but unnecessarily or in a routine manner also this court cannot grant an inquiry to be made. The circle officer has already made an inquiry, and it appears that it is a detailed inquiry. At page 231, running page of the affidavit in opposition of R2.
231 is our reply.
No, 231. With a view to find out the actual state of affairs on the allegation of the petitioners, an inquiry was directed to be conducted. Have you reached there? By the circle officer of Morrigaon?
Yes.
Yes, read that.
It may not be our construct to mention that inquiry report has been submitted by the circle officer of Morrigaon Revenue Circle and executive engineer Morrigaon Water Resources Department in concern. A pre-constructed embankment is there in Dakhin.
So what are you reading?
I am reading their opposition.
Yes, at page 231. Internal page 3.
I'm not sure. 231 is our reply.
You take the affidavit in opposition filed by R2.
I have the affidavit in opposition of R2.
Go to internal page 3.
Yes, your internal page 3.
Second paragraph, read.
With a view. Yes. With a view to find out the actual state of affairs on the allegations of the petitioner, an inquiry has been directed to be conducted by the circle officer Morrigaon Revenue Circle along with the executive engineer Morrigaon Water Resources Department. On such inquiry, along with the examination of relevant records, the above narrated facts have come to light. It may also be pertinent to mention that the present embankment was in fact constructed in the year 1960, and in the office of the district commissioner no records whatsoever relating to any land acquisition process during the construction of the said. Means they are saying that in the year 1960 there is no record with them.
The embankment was constructed in that year, so if land has to be acquired, it has to be acquired at the time of construction.
Yes.
Isn't it?
Yes.
Then, in view of the matter,
no land acquisition was carried out for the purpose of implementation of the present scheme, namely RS.
So what more inquiry is required? You have no case, sorry. Heard Mr. S.S. Raman.
M.R. Sodial.
Mr. M.R. Sodial,
yes.
Learned Counsel for the petitioner stopped. Also heard Mr. V. Goswami, Learned Additional Advocate General Assam, assisted by MS M. Bormon, Learned Government Counsel Assam. For all the respondent numbers 1 to 4.
2 and 4.
Water Resources, they have their own council also.
So for the state respondents.
Yes, state respondents.
For the state respondents. Stop. The writ petitioner, by filing the writ petition, is canvassing non-payment of compensation by the Water Resource Department, Government of Assam, for construction of embankment from within quote R/S to T/DVKE along both banks of Kopeli River from so and so to ইয়াক মই আন্ডাৰলাইন কৰি দিছোঁ, পেজ 2 পাব। Stop. The facts of the case is that the petitioners are owner and pattadar of different plot of land which are covered by DAG number 28, patta number 224, DAG number 193, patta number 105, DAG number 14, patta number 223, DAG number 34, patta number 154, and DAG number 300, patta number 200, DAG number 519, patta number 199, DAG number 6, patta number 141, DAG number 203, patta number 54, DAG number 154, patta number 159, which were alleged to have been acquired by the Water Resource Department for construction of embankment in the subject embankments including anti-erosion measures at different reaches. Stop. It is the specific case of the petitioner that the Water Resource Department Morigao Division, after acquiring the said land of the petitioners, did not pay any compensation amount to the petitioners, and accordingly the present petition has been filed. Stop. Mr. M.R. Soedial Learned Counsel for the petitioner submits that the petitioner's land has been acquired by the Water Resource Development for the subject embankment and without payment of compensation. Stop. Next para. Mr. B. Goswami, Learned Additional Advocate General, Assam, submits that the land of the petitioner was not acquired by the Water Resource Department.
My Lord, acquiring authority, my Lord.
By the acquiring authority in connection with the subject embankment as alleged by the petitioner, and as such the petitioner is not entitled for any compensation whatsoever. Stop.
It's a pre-existing embankment.
I have heard the submissions made at the bar and have perused the materials available on record. It appears from the affidavit in opposition filed by the respondent number 2, the District Commissioner Morigao, Assam, that there was an inquiry as regard the conducted by the Circle Officer of Morigao Revenue Circle along with the Executive Engineer Morigao Water Resource Division, and after conducting the said inquiry, a report was submitted from which it can be seen that the land of the petitioners was not acquired in connection with the subject embankment. Correct? Stop. Relevant paragraph of the aforesaid affidavit in opposition is reproduced hereunder for ready reference. Paragraph 4 with quote unquote koribo. Paragraph 4 opra arambho koribo. Page 230 running page. Moi eta pink flag dise de. একেবাৰে 234 লৈকে আছে। It is evident from the above that no land of the petitioner has been acquired for the purpose of execution of the present scheme, namely, etu reference to agot ase, etu loi lobo, so and so, page 235 or 2 pabo. As the same has been implanted on the pre-constructed embankment in Dokhin Dharmatul Revenue Village. Stop. That being so, the writ petitioner has failed to make out any case warranting the relief sought for. Stop. As such, the writ petition stands dismissed. No cause.
My lord, earlier petition whatever was vacated, my lord.
Mr. Roy, at least have one of your junior in the court, because this court has been noticing since Monday that all old matters, nobody is there. At least,
my lord, it should be there, my lord.
What was your item number?
23.
Interim order to OPIC কৰি দিব, সেইটো গুচাই দিব আৰু টিকেটৰ এপিয়াৰেঞ্চটো হেৰি কৰি দিব।
Oblige that.
এইটো ডিসপোজ অফ হৈ গ'ল।
My lord, I am a writ petition of the IA filed by the applicants. 2315, my lord.
Yes. Sorry?
I am a writ petitioner, my lord. IA filed by the applicants.
There is an IA.
For impleading as respondent.
There's an IA for implement?
Yes, we have filed for
IA at us.
2315.
Who are you?
My lord, land has been allotted to us, my lord, on our application. Following due process, there has been an allotment of land in my favor on payment of premium, my lord.
You are the allottees?
Yes, my lord.
You are the allottee to the subject land?
Yes, my lord.
And what is the writ petition for? You want yourself to be included in the writ petition. What is the writ petition for?
Already party আছে। No. My lord, I am already in party.
You are not even aware as what is the application on record.
My lord, that has been wrongly filed. My lord, I am already
wrongly filed.
My lord, that is we are already in my lord, respondent number 5. Huh?
Mr. Counsels, please resolve the matter and then appear. Please check the files. Next. Don't take judicial time for granted. Next matter. Yes, 27, Mr. Mondal.
In this case, subsequent development is occurred, so we need 1 week time to file additional affidavit.
It is submitted by Mr. M.U. Mondal, Learned Counsel, for the petitioner that in the meantime there has been some development in the matter, which he praised to bring on record. Stop. Prayer is not opposed by the respondent. List this matter after 2 weeks. After? After 1 week on a date to be fixed by the registry. Yes, Mr. Sahewala.
IA, my lord. Last time, my lord.
There is an IA.
This honorable directed the government advocate to take instruction.
We have
because.
Have you received the instructions? What is the IA for, Mr. Sahewala?
Well, IA, my lord, not to make any construction over the land because the land was, I am in possession for the last 20 years. And everything complete, my lord, for settlement of the land. There is a letter, my lord, you have to also see page 29.
Yes, what is your instruction?
According to our instruction, the report, according to the report of the circle officer, Jorhat Revenue Circle, and submitted dated 31/8/2020, it is come to the notice that the petitioner has no possession over the aforesaid plot of.
You are saying you are having possession. Then let this be filed by way of affidavit, because according to the instruction, you are not in possession.
All the documents are there, my lord. They are documents.
Very well. Then
only my lord, thing, my lord, status quo will be maintained till then.
No, the report is negative, Mr. Sahewala, as regards your possession. So let it be filed by way of an affidavit. I am not disposing of the IA.
No.
We will give a short date. And in the meantime, you bring whatever reply you want to bring in. When can you have it? We'll fix this matter on next Khular episode.
After Bihu.
First day? 18th? In the IA likhibo. You are?
S. Borwa for 3 and
MS S. Borwa, Learned Counsel, Learned Government Counsel, appearing for respondent number
325.
325 submits that she has received instructions in the matter which indicates that the petitioner is not in possession of the subject land. Stop. Accordingly, let the same be filed by way of an affidavit. Stop. List this matter on 18/4/2024. Stop. In the meantime, if the affidavit is filed, the petitioner is at liberty to file appropriate reply.
payment.
Part payment has been made?
Yes, and that is reflected in order dated 5/6/23 of this honorable court.
Part payment has been made by whom?
By the executive engineer, my lord.
And he is a party here?
Yes, of course.
Then he is already there.
And I have filed my additional
Who is
affidavit.
appearing for R3?
There's an
Executive
additional
Engineer,
affidavit.
Water Resource
Lordship.
Division?
Lordship, I'm appearing for
So, yes,
Lordship,
you have already made
recently
part
we have-
payment. Why
Yes,
the
Your Lordship,
balance
but the-
payment has not been
But the
made?
rest of the payment is to be made by the Ministry of Jal Shakti.
That was unheard of, my lord. In the work order, that was never mentioned.
No, but
So
you
recently
see,
we have received
unless you
the
file all this, an affidavit, or you place some instruction, how is this court going to proceed in the matter? If that is the objection, according to you, the balance amount is going to be paid by another authority, then bring it by an affidavit.
Lordship, I
You
was-
cannot be taking the petitioner by way of a surprise. These are admitted contractual amounts. It cannot be kept hanging like this.
Lordship, I will file the
When?
within a week.
Your name?
D Jane.
MSDJ?
Yes, Your Lordship.
In Learned Council for?
Water Resource Department.
For the Water Resources Department submits that. How much payment has been made?
80,776.
That a payment of rupees
80,000. I am sorry, my lord. 8,776.
That a payment of 8 lakh.
I'm sorry, I'm deeply sorry, my lord. Not
The
8 lakh.
council.
Part payment, my lord, at para
79,400.
79,000, yes.
420.
420.
420.
Yes, ma'am.
That a payment of 79,420 out of
Out of
Out of
9 lakhs.
9 lakh.
9 lakhs
2,496.
2496.
Yes, Your Lordship.
Out of 9 lakhs 24,096 has been paid by the Water Resource Department. Stop. She further submits the balance outstanding is to be paid by
Ministry of Jal Shakti.
Ministry of Jal
Shakti.
Shakti. Log the details too. However, the SEM is not a party before this. No, don't say that. Let the same be placed by way of an affidavit. You bring an affidavit.
Yes,
List on last working day. Did your poetry 10. List on 10. You file an affidavit before 10.
Yes, sir.
List on 10/4/2024.
Next matter is similar, my lord.
Similar matter.
31 and 32.
Yes, sir.
But the amount is different, my lord.
Give the amount in 32. How much has been paid and what is the total? Can you please give it? It will lower it.
Same date.
All right.
Yes.
May I please, Lord?
Yes.
Lord, matter pertains to my lord recovery of my lord forest
royalty.
Lordship. What you may see the last order, my lord, on that day also, my lord, no one has appeared for the my lord forest as well as my lord NSIDCL. Though my lord, the National Highway Authority has filed their affidavit and we have also filed our reply, my lord.
What is their stand? Why this forest royalty has not been paid?
No, my lord, we have categorically stated, my lord, we submitted our reply, my lord. In fact, my lord, this is the fourth notice, my lord. First, my lord, notice was issued by the Conservator of Forest, my lord, by making a demand of rupees, my lord, 12 crore. Thereafter, it was reduced to 3 crore. Against that order, we have approached this honourable court, and this honourable court has stayed the operation of the said recovery, my lord. In the meantime, my lord, the DFO, my lord, he has made a fresh assessment of rupees 15 crore. Thereafter, it was increased to, my lord, 40 crore, my lord. And, my lord, while issuing notice, my lord, that was stayed, my lord, and, my lord, on the last occasion, my lord, they have.
What is their stand in their affidavit?
My lord, NSIDCL only said, my lord, since it is a
Who is required? Who has issued the demand notices?
My lord, that is the DFO, my lord.
DFO.
Lord.
What is the stand of the forest?
The forest said, my lord, we have not disclosed the entire, my lord, the utilization of forest produce, my lord, and accordingly they have, my lord, imposed this demand, my lord. They have made this demand.
You are challenging the demand.
Lord.
Where is the demand?
Lordship. That is, lordship, annexure, my lord.
What are these 2 volumes?
Yes, lordship, because we have annexed the entire contract, my lord. That is, my lord, Annexure 18 at page 174 in volume 1, my lord.
174.
Lordship.
Yes. Yes, 16,323.
Lordship. So, my lord, on once page number 175, the grand total due, that is Lordship 40 crore 4 lakhs, my lord, 4,926.6, my lord. So it was, my lord, intimated to the, my lord, the respondent number 6, my lord, to hold this amount and to pay to the, my lord, forest department.
What is wrong with this demand?
My lord, the matter was earlier chased by another authority, my lord. He has, lordship, the raised demand of rupees initially 12 crore, thereafter it was reduced to, my lord, 3 crore. And contract was terminated long back. It was, my lord, foreclosed. And based on the same material, my lord, he has...
Have you filed reply against the 16,323 demand?
Lordship.
Have you filed a reply?
Against this, my lord, we have not filed, my lord. 16.3 it was not filed. Because, my lord, we have approached this honorable court and this honorable court, my lord.
So, but now you are seeking a mandamus.
My lord.
You are seeking a mandamus.
Lordship.
And you have not made a demand before coming.
Lordship, because, my lord, see the sequence, my lord. Based on the same materials, my lord, because the dates are very much important, my lord. The contract was foreclosed, my lord, long back, my lord.
When was the contract
closed? Yes, my lord. The contract was foreclosed, my lord, on 29/10/2021, my lord.
29/10?
2021, annexure to page 61, my lord. And this includes...
Page,
lordship, 61.
Yes.
And, my lord, this demand was issued, my lord, on, my lord...
23.
Yes, lordship, 16/3/23, my lord. So thereafter, my lord, from 21 to 23, my lord, no work was executed. And in fact, the initial, my lord, demand that was issued on, my lord, lordship, that was issued on 28/7/2022, my lord. So, my lord, when the contract was foreclosed, my lord, and no work was executed, my lord, and
Is
based on
there
the...
an arbitration clause in the contract?
Lordship. My lord, it was not the...
There is.
There is, lord.
Where is it?
My lord, clause 26, lordship, that is clause 26 of the contract agreement, lordship, that is in volume 2, my lord, page, lordship.
You are for the forest?
Our instructions are awaited, lordship. May grant us some time.
What instructions? You have not filed affidavit.
Lord, page 293 of volume 2, my lord.
Page 2?
293. That is with the, my lord, any dispute with respect to, my lord, the authority NSIDCL, not with the forest, my lord. Here, my lord, we have challenged the action of the forest, lord.
This contract is between?
Between, my lord, National Highway Authority of India, lordship, National Highway...
Then we admit this for hearing.
Lordship.
This is item number?
33.
Heard Mr. S. Chetia, learned counsel for the petitioner. Stop. Also heard Mr. I. Borthakur, learned standing counsel forest. NHIDCL is a party here. Their name is not reflected.
No, my lord, the reference number 5 and 6, my lord. They appeared, they filed their affidavit, we also filed
It appears that the petitioner has a it appears that petitioner has made out a case for hearing. Stop. Admit, since parties are represented, no formal notice. List after 2 weeks. For list after 2 weeks for hearing.
Let it be in the month of May, lord.
All right, list for hearing in the month of May.
Lord, please. Interim may continue, lord.
Interim passed earlier shall continue. In the meantime, you want to file affidavit or
We'll
affidavit
file
is there?
affidavit,
Huh?
We'll file affidavit.
In the meantime, Forest Department shall file their affidavit.
Deeply obliged.
I have received instruction. I'll file my affidavit. I have received instruction.
You have received instructions?
Yes. In the office of the Deputy District Commissioner, Lordship.
Mr.
S.R. Borwa.
Mr. Datta, you want to say something?
I am for response number 2 and 3. We have already filed our response with a prayer for deciding an issue of maintainability that your lordships have recorded in the order.
Very well, then we will not record that today. It is already part of the judicial order. We will simply adjourn on his request today. In the meantime, have you filed the reply?
No, Lordship.
You file your necessary replies in the meantime.
My prayer,
yes,
Lordship.
Mr.
S.R. Borwa.
S.R. Borwa, learned government advocate or standing counsel revenue?
Junior government advocate.
Junior government advocate has submitted that he has received the necessary instructions in the matter and accordingly seeks accommodation for filing the same. Stop. Prayer is not opposed by the petitioner. List this matter after
2 weeks.
2 weeks on a date to be fixed by the registry.
Lordship.
And in the meantime, it is needless to clarify that the petitioner is at liberty to file reply to the affidavit in opposition filed by the respondent number, Mr. Datta? 2 and 3. Filed by the 2 and 3.
Lordship may kindly record our presence.
Please give the appearance slip. The divorce of our presence.
Lordship, we have newly implemented 3 parties. Resolution number 7, 8 and 9.
Notices have not gone?
No issue.
Implement has been done? Respondent numbers? 7,
8 and 9.
8 and 9. Where is that order?
On the 5th of January, IA was allowed for correction of cost title.
Notice may be
3757.
5-1?
5/1/2024.
Yes, yes.
Notice may be issued, Lordship.
But the
Notices was not issued, it appears. All right. Have you made corrections? Yes. It further appears that notices to the newly implemented respondents has not been yet issued. Stop. Let notice be issued to respondent number
7, 8 and 9.
newly implemented respondent number 7, 8 and 9. But 7, 8, 9, I think government can appear.
No, I'll appear on behalf of only respondent number 9, Lordship.
And
Officer
what about 7? DFO?
Forest Department.
Forest, Mr. Borthakur is there. Can anybody ask Mr. I Borthakur to be here? I'll record his name. 7. And 8, I think, by registered post.
Yes.
Mr.
S.R. Borwa.
S.R. Borwa, learned government advocate, accepts notice on behalf of 9. Mr. I. Borthakur, learned standing counsel, Forest, accepts notice on behalf of 7. Let notice by way of registered post AD be steps by registered post ID in respect of 8.
Then after Lordship 4 weeks, then
4 weeks.
Obliged.
Item 35.
Extra
It
copies
gives your
in the
lordship.
course of the day.
Lordship, the petitioner is the owner of the 4 numbers of vehicle, and all the vehicles are hired by the respondent authority. Lordship.
Yes, payment, hiring charges.
We are yet to receive our instruction, Lordship. We need instruction.
First time it has come.
Second time.
After
Second time.
Today is the returnable date.
Yes.
You file your affidavit.
Yes. After 3 weeks, Lordship.
Mr. A.R. Bhattacharjee, no?
S.R. Borwa.
S.R. Borwa. Mr. S.R. Borwa, learned government advocate, 2 weeks time to file affidavit in opposition in the matter which is not opposed by the petitioner. Stop. List this matter after 2 weeks on a date to be fixed by the registry.
Finding admission matters, item 17.
Yes. Manoj.
May it please your lordship. The matter pertains to the illegal encroachment of my plot of land, lordship, measuring 4 bighas in the Dulasa in Dag number 4.5 and measuring 1 bighah in Dag number 277.
GMDA was required to make some report.
Let the report come up.
No, what do you mean let the report come up? What has happened? You were already asked to submit the report. This court fixes the matter again on 5th January so that an update can be given by the Learned Standing Counsel for the GMDA as to what further actions have been taken pursuant to the report which is likely to be submitted. Yes. Where is your instruction? Matters. You are the Standing Counsel?
4.
Who is R4? GMDA?
No, sir. I am respondent of Praveen Bora. Respondent of 4.
You are not for GMDA?
No.
Who is appearing for GMDA?
Lordship, my senior Mr. P. Nayak is on legs right now.
But whether the instructions are available or not,
Lordship,
this matter has been already called once. Since there was no representation from GMDA, the matter was passed over for time being.
Apologize, he was even then on legs.
GMDA, how many lawyers are there standing counsel?
Lordship, in the meantime, GMDA authority have issued a status of the land, Lordship,
yes,
seeking a direction. This letter is issued to the land giver's name, Praveen Bora, the respondent number 4. Kindly peruse the paragraph number 2, Lordship.
This is absolutely not legible, Mr. Counsel. You don't have a clear copy?
Copy of the same has not been provided to me, Lordship. Lordship, kindly read over.
This is a notice which was issued.
Yes, Lordship. On 5/1/2024.
To Praveen Bora.
Yes, Lordship.
Praveen Bora is the
land giver, Lordship.
So what happened after this notice?
As per this notice, you have to.
You are appearing for the Praveen Bora?
Yes.
So what happened after this notice?
I don't know, Lordship, whether a reply has been filed or
not. Have you
not.
filed any reply in the matter?
We have filed the affidavit in opposition.
You have filed?
Yes.
Have you clarified what happened after 4th of January 2024? Because your affidavit is, I think, of 2022.
Yes. 29 dated 29/11/22.
2022. But it appears a notice has already been issued to you to
submit the NOC.
No. Yes. Notice is issued under section 87 to show cause as to why the unauthorized construction should not be demolished. What happened after that? Neither you are disclosing nor the counsel for GMDA is disclosing anything. What happened after this notice? There is a judicial order asking the counsel of standing counsel GMDA to place all this before this court.
Give us certain time to file a surplus notice against the surplus notice.
The instruction as sought for by this court-wide order dated 21/12/2023 is not available before the learned standing counsel for the GMDA today when the matter is called. Stop. List this matter on 23rd, on 23/4/2024.
Later then it will be available.
For to submit up-to-date status of the to update to submit update in the matter.
Madam. Can it be
in the meantime, respondent number your respondent number
4.
Respondent number 4 is allowed to file an additional affidavit to bring the update materials on record. You've already filed once. You want, you can always file by that date. You have sufficient time. Yes. Yes, Mr. Nair.
I am the owner of a certain plot of land, my lord, that has been occupied by the army, my lord, without any requisition or acquisition, my lord. That is why I am before lordships. My lord, the district administration is filed.
Affidavits filed?
Yes. My lord, by the district administration and by the army, the district administration says that since it's a transferred subject to the BTC, my lord, so therefore they are answerable. The army says that they have been authorized by the district administration to be there in that plot of land. And there is a verification report.
Mr. Goswami, the factum of acquiring the land of the petitioner is not in dispute. Then the petitioner is entitled for a compensation. Who is to pay the compensation is for you all to decide.
This Kala law, this is by the BTC laws. This is by the BTC laws.
By the BTC? Laws. Yes. What is the stand? You cannot be shifting the blame from one department to the other. Somebody has to pay. And the question is when this payment is going to be made. That's all. It's a matter of 21.
Lordship, I am very sorry. This case is today allotted to someone else, Lordship, after time being Lordship.
Please don't make all these submissions before this court. A matter is listed. If you are a counsel,
yes, but file is not with me. That is my
it is
problem.
for you to ensure that that you have the file.
Lordship,
when shall we have this matter? Tomorrow?
Lordship.
Or at 2?
At 2 p.m. Lordship, some other counsel may appear, Lordship. I shall inform him.
My lord.
At 2 or tomorrow?
As per Lordship's convenience, my lord.
As per Lordship convenience.
We're having it tomorrow. In the meantime, you find out. The only thing that this court is concerned is about the compensation. Right? That is the only issue?
Yes, Lordship.
It is submitted by MS R. Boro, learned R.B. Boro, learned counsel for BTC, that another standing counsel is handling the said matter on behalf of BTC and accordingly seek some accommodation. Stop. List this matter tomorrow, on which date the standing counsel BTC shall apprise this court as regards the status of the payment for compensation of the petitioner's land.
Deeply obliged.
Deeply obliged.
Item 26.
May pleasure, Lordship. My Lord, I am sorry, my Lord, there is an IA 2315.
There is an IA?
Yes, my Lord. That may be not placed, my Lord.
Not clear.
Not placed.
Okay. In IA 2315 of 2023, Mr. A.R. Sikdar, learned counsel for the appellant, submits that he has received instructions from the appellant not to press the aforesaid application for implement of respondent number 7, 8 and 9, 8, 9 and 10 in the connected writ petition. Stop. In view of the aforesaid endorsement, the IA stands disposed of on withdrawal. And you also record the name of Mr. I.A. Talukdar for opposite party in the IA. Disposed of. IA is disposed of, and writ petition?
In respect to the writ petition, my lord, I received the additional affidavit from respondent number 3. I want to file rejoinder now.
In the writ petition, you say the Mr.
I.A. Talukdar.
I.A. Talukdar, learned counsel for the petitioner, submits that he desires to file a reply to the additional affidavit filed on behalf of
Respondent number 3.
Respondent number 3. Stop. Prayer is allowed. List after 2 weeks on a date to be fixed by the registry.
Leave lovely.
Supplementary list for admission.
It is 20 as in nigga. IA disposed of. Next, Himal. Yes.
Lord, we are led by Mr. K.M. Chaudhary, and I believe the standing council, the government council is also on legs in court 7.
Now, what is the matter? Petitioner is appearing in person. He has been waiting since 10:15 in the court.
My Lord,
Yes.
my Lord, the basic grievance, as is shown in the writ petition, is that approval was sought for initiating a criminal investigation against me under the PC Act. My Lord. So the writ petition was filed alleging that the authorities have not dealt with the issue of
A
approval.
sanction was sought for
Yes.
to proceed, and that same has not been
done.
acted upon.
And has not been acted upon, but in the meantime, the state authorities filed an affidavit stating that the sanction has been refused.
Has been refused?
Has been refused. Now, that refusal order per se is not under challenge, my lord. So, if your lordship takes up the initial prayer of the writ petition.
Yes.
Prayer was a writ in the form of mandamus shall not be issued, thereby directing the respondent authorities, specifically respondent number 2, to take into consideration the approval request for initiation of criminal case
Now,
against.
this, according to you, has been denied. Approval has not been given.
It was refused. That was brought on record with the state respondent.
That is not under challenge.
That is not under challenge. So perhaps a new fresh cause of action may have arisen, and now they're taking a different stand that the
competent authority which had refused the sanction was actually not the competent authority.
Be
That
that as it may,
this order is not
sanction,
under.
the refusal of the sanction order
Is not
itself now has to be challenged, correct?
Yes.
Yes, what do you have to say to that?
Lordship, my submission in this court is on the basis of query raised by the Honorable Court. Court has specifically asked me to submit that who is the authority who is competent.
Before we go to who is the competent authority, first let us understand one thing. Let us be clear on facts.
Yes,
the writ petition which has been filed before this court, in that writ petition, your specific challenge was the non-action of the respondent authorities in issuing the necessary sanction, correct? That was the issue?
Yes,
after
issue that is there.
Correct. Now, after filing of this writ petition, that action has been taken in a negative form as far as you are concerned, correct?
Yes.
So there is an order whereby the sanction was refused. Now that order is not challenged before this court.
Yes.
Correct or not correct?
Yes, my lord.
Now if that be so, either you amend the writ petition or you withdraw this and file afresh. Or we keep this pending. In the meantime, you file another writ petition because that order has to be under challenge. These are technical issues. You may not be aware of the technicalities, but
Let me allow me
yes,
the submission.
because the
My
other
writ
issue,
petition-
whether that person is competent, not competent, whether he has jurisdiction, no jurisdiction,
Everything is
that
in order, Lordship.
Yes.
Please allow me some
Yes,
submissions. Petitioner number 1 filed a writ petition in 2020, 5332/2020. Accordingly, on 6 January 2021, a notice was issued by this Honorable Court. On the very next day, a letter was drafted at respondent number 4's office, and accordingly approval was granted by the then Director Vigilance and Anti-Corruption on 12 January and 13 January. They served one approval for registration of criminal case under section 13(1)(b) and 13(2) of PC Act in the matter of disproportionate assets amounting rupees 2 crore 16 lakh.
approval was given.
Lordship, under which section this approval has been served, that is the most important question. There are only two sections in the Prevention of Corruption Act. That is, one is 17A and one is section 19. Section 19 is the prosecution sanction, and section 17A, which was amended in 2018, is for approval for inquiry and investigation. That sanction does not cover the matters related to disproportionate assets. There is no requirement of any approval, Lordship, in the matter of disproportionate assets. That is the case. And approval has been sought. Approval has been kept pending for 3 years, almost 3 years. When the writ petition was there, hurriedly during the pendency of the writ petition, the courts, the respondents' government as well as the agency, Vigilance and Anti-Corruption Agency, shouts again and again adjournments. Then they shout a written submission in this court that 30 days time may be granted for submission of action taken report. Then they start a parallel inquiry which was lasting for just only 5 days. Court has granted adjournment on 15th May. On 15th May the inquiry was ordered. On 15th May the whole process of letter in the government as well as the agency has been done. On the 15th itself they served the respondent number 5 to their agency on the very next day. Within 5 days they complete the inquiry and submit one document to the government. And everybody is in dark. I am the complainant. I am in totally dark about the inquiry. This court is completely in dark about that inquiry. And they submit the order. Order says that...
Which inquiry?
Please see the affidavit filed by the government. That itself will explain everything.
Affidavit filed by respondent number
1.
Yes.
Means this is an entire scandal. How this has been there? They are acknowledging the government in its order, which is signed by the Secretary Political Department. They are acknowledging that I am the complainant. In the first paragraph itself.
First, kindly clarify one thing. You have made submissions that here approval is not required. This is
They
what
are denying any action on the basis of that approval.
you have just made some submissions. One of your submission is that in relation to the misappropriation amount, approval is not required.
Yes, ma'am.
Correct?
Yes,
This is your submission?
Yes,
Now kindly see the prayer that you are asking. You yours
they are
kindly
denying on
see
the basis of
the
this.
kindly see the prayer that you are
Yes,
making
yes, Lordship.
at page 17. Kindly read that prayer.
Yes, Lordship.
Please read.
I have already read out, Lordship. I have sought that respondent number 2 should be given because the government and the agency, both, they are saying that they are the competent authority.
Mr. Sharma, please
Vikas.
try and understand the query that has been put to you.
Yes, Lordship.
Because unless and until the facts are clarified, this court, it will be not possible for the court to pass any orders. If you want some orders from the court, then please answer the queries.
Yes, Lordship.
What is the prayer that you have sought at page 17?
My prayer is that, Lordship, that
Kindly see. Shall not be issued thereby directing the respondent authorities to take into consideration the approval request for so and so, and after perusal of the same grant immediate appropriate government approval,
Or rejection.
sanction or rejection as the case may be, after examining the same. This is your prayer in the writ petition.
of letter dated 13/1/2021.
Be that as it may,
The denial
be
is
that
on
as
the
it
basis
may.
of 25/2023. That is the defective
You
thing.
see, after filing this writ petition,
Yes, Lordship.
the authorities have passed an order. The authorities,
They have
is it-
passed the order.
Has
not-
the authorities passed an order or not, Mr.
Sir, they
Sharma?
submitted
Your
an order
name is
which
Mr.
is-
Sharma?
which is
Your
Vikas-
name is Mr. Sharma?
Vikash Bucha.
Huh?
I am petitioner in person, Vikash Bucha.
B. Bucha.
Yes, Lordship.
Mr. Bucha, is it correct or not that
Sir, in these matters, Honorable Supreme Court has made clear guidelines.
We'll
There
go
the
to the
documents
guidelines
which has
later.
been submitted, the documents which has been submitted along with the proposal for approval, sanction, whatever, the decision should be taken on that. If letter dated 13/1/2021 can contain the report dated 25/2023, is
Mr.
it
Dekam,
possible?
where is the sanction, that sanction order, no, rejection order?
Rejection order is in the affidavit, my lord. Filed by the respondent number 1 at page 48.
Page 48.
Annexure A.
Any reply filed to this AO?
Yes, Lordship.
Yes.
Where is that?
Reply filed on 1st of November, Lordship. A detailed reply has been filed.
Page 105 onwards.
Yes. Is not here. Okay. The rejection order is dated 10/6/23.
10/6/23.
I see.
And in this reply, they've tried to find fault with the order. The order could be bad, but unless there's a
Yes,
challenge,
Mr. Dekar, to that effect, there is no
The
difficulty.
judgments,
If we technically see, the order has to be under challenged. But nonetheless, since this is a 226 that we are that this court is exercising, if this court find there is some illegality, the arms of this court is wrong,
Obviously,
and we
there's
may
no
not
question.
insist on
True,
technicalities,
true,
right?
True.
The only thing is that facts are not absolutely clear right now, but on the face of it, you are absolutely right that
Lordship, the last order of the
relief
court
that
may
was
kindly be
sought
seen.
in this writ petition was specifically
That you
non-action on the sanction sought. Now that has been acted upon, the sanction has been rejected. They may have a very strong case, nonetheless the same has to be challenged. Without there being a challenge, this court perhaps will not be able to go into that. That is one way of looking into it. There is not. Now that is why this court was suggesting that either we can post this matter on another date. In the meantime, in order to avoid these technicalities, you may file another fresh petition and challenge the sanction order. You will have to say all that you have said in your reply.
No.
You file another writ petition, that will solve your problem.
Lordship,
otherwise later on you are going to have problem. This court is trying to help you. This court is with you as regards the points that you are stating.
This is duly agreed, Lordship. In the last order, this Honorable Court had specifically asked instruction from respondent number 4.
Where? In the order dated 13-3.
13-3, my lord.
this order needs to be complied today, Lordship.
Now, on the next date of listing, the petitioners shall apprise who is the authority competent to remove an MLA from his office as per section 17A. Would be the speaker. Accordingly, submit that the order passed on so-and-so by the political so-and-so is non-est in law, as the same has been passed by an authority without jurisdiction. Yes, government advocate.
My lord, I have placed one instruction received on 1st of April 2024 as for the specific inquiry by the Honorable Court.
All right, then.
On the next page, my lord, is the
then we
judicial.
shall give you some time. You
We
get
may
it.
file an affidavit, my lord.
It appears that by order dated 13/3/2024, this court had specifically asked the junior government advocate to place on record, to place specific instructions with regard to the submission made by Shri Bikas Bucha, learned petitioner number 2 in person, to the effect that the competent authority under section 17A of the Prevention of Corruption Act is the speaker. Stop. However, the said informations are not though MS
U Sharma,
Leonard Government Advocate Assam has produced an instruction dated 1st April 2024, issued from the Office of the Joint Secretary to the Government of Assam Political Vigilance Sales Department, enclosing the views of the Judicial Department and the Legislative Department in the matter. it is desired that the said instructions be filed by way of an affidavit by furnishing a copy to the petitioner to the petitioners. Stop. List on
Any date, my lord, or week?
So any date in this month?
Did you? All right.
Yes, okay.
I shall just resume in 5 minutes.
Obliged.
Wait, please, Your Lordship. Lordship, I am for item number 2 and 36, Lordship.
Yes.
Here, FIR, Lordship, will find on the page 21, Lordship. This, in item 2, Lordship, I am appearing for the two of the accused, Lordship. They are named Jahed Ali and
Let us have
Shahjahan.
one by one. Item number 2.
I am representing for two accused petitioner, Lordship, Jahed Ali and Shahjahan Ahmed.
Where is the FIR?
FIR that is on page 21, Lordship.
They are all named.
No, Lordship. These two petitioners are not named in the FIR, Lordship.
And in item 36?
In item 36, their name is not there, Lordship.
How long are you there?
In the Lordship, item number 2, this petitioner arrested and forwarded on 14/3, Lordship, today 21 days. In item number, Lordship, 36, they were arrested on 15/2 and forwarded on the same date, Lordship. In that case, today, Lordship, is 49 days, Lordship. Now, Lordship, in...
you have received the case,
Yes,
right?
Lordship, yes, there is there, my
Any
lord.
advance materials?
Yes, my lord, they are very much involved with the crime. There are several persons, my lord, around 8 to 10 persons they were named, my lord. Out of them, they are before
Overt
the lordship.
act?
Yes, my lord.
Overt act against the petitioners?
Yes, my lord, very
What?
much. My
What
lord,
is
my lord, they are the persons, my lord, who what they do, my lord, they used to, my lord, offer pure, like they want to sell a pure gold. Afterwards, my lord, they contact all the persons from over India, my lord. When they came, my lord, when they come, my lord, they used to loot them.
This
with,
is
my lord.
second time?
Yes, this
No,
is second.
no.
Yes,
For
yes.
item number 2 and 36, for the first time, Lordship, before the High Court, Lordship.
Yes, earlier it is my rejected on item 55. Your Lordship may kindly see page 24, your Lordship's order, my lord. 55. Item 55, your Lordship may kindly see page 24.
Same FIR?
Same FIR.
22-124.
Yes.
Here also, have they confessed their involvement?
Yes, my lord. And from them also, my lord, the fake gold
have been
and
recovered.
Yeah, recovered, and other pieces of gold are also recovered, my lord.
Lordship.
In item 36, earlier one, my lord, regarding that 36, and here also, my lord, the
In
same.
item 2?
Yes, item, my lord.
55.
This is item 2, my lord. They were arrested on.
All right, one by one. Just 1 second. As far as 55 is concerned, any change of circumstances?
Lordship, if I may be allowed to read paragraph 7 from page 7. Page 7, paragraph 7.
Yes.
The petitioner states that so far the sections charged against the petitioners are concerned, except section 489B of the Indian Penal Code, rest of the sections charged against the petitioners are punishable by a maximum period of 10 years with fine. And further, from the bare perusal of the FIR itself, it appears that the ingredients of commission of offence under section 489B of the Indian Penal Code is very much absent so far the present petitioners are concerned. And as such, the petitioner should be granted with the benefit of maximum period of detention of 60 days as per section 167 of the CRPC if no charge sheet has been laid by the investigating agency in time.
How many days in item
As of
55?
today, it's beyond 60 days. For
Beyond
petitioner-
60 days?
Yes, Lordship. For petitioner 1 to 3, it is 70 days.
71,
And
more than
petitioner
70 days.
4 is 67 days as of today.
Yes, length of detention. What has
yes,
the,
yes, length of detention, Your Lordship, I leave it to Your Lordship.
No,
But
is
what,
there,
what,
Mr. MPP, is there any adverse material as regards the antecedent of the petitioner?
yes, ma'am.
There are.
Yes, ma'am.
What is it? Antecedents. You have reasons and materials to show that they may not cooperate with the investigation or the trial?
As per their own statement also, they are doing this business from time long enough, my lord. And they were...
That is there.
Yes.
But any other cases pending?
Yeah,
Anything earlier they have been charge sheeted? That is not there. So, therefore, you have... Except from what they are saying,
yes,
there is no other adverse materials as regards the antecedent, correct?
Yes.
Now, therefore, the question is, you see, bail is not punitive,
No.
nor preventive.
No.
It is the object of bail is to secure their appearances at the time of trial by securing a reasonable amount, correct?
Yes.
So that is why I am asking you this specific question, because 71 days.
Yes.
They have been languishing in the jail. Investigation.
Yes, investigation is, my lord, somewhat progressed, my lord. Now the
Is it somewhat or substantially progressed?
Not substantially, because what I am saying, so my lord, from their, my lord, investigation, in item number 2, your lordship will find the other 3 petitioners.
Let's not jump around. In item 55.
From their interrogation, those persons were arrested, my lord. And now, my lord, regarding those persons, it is not revealed in the CD because today is for the motion, my lord. And in this way, investigation is going on, and several persons are yet to be arrested.
So
also.
you are saying that in regard to item number 2 and 36.
2, yes, 2, my lord, it is a motion.
2 and 36.
36
in hearing matter.
36 in hearing matter.
But your CD has covers 36?
Yes, CD covers 36 and 55.
Not 2.
Not 2. My lord. And regarding that one, it's a 90-day offence, and what has been stated in the paragraph, my lord.
Are there more people involved, or everyone involved has already been now arrested? Because one of the ground for which this bail was at that time not granted is because from case diary it appears that the involvement reveals that there are involvement of more co-accused in the case, and along with their accomplices they run a well organization of fake gold smuggling. And after this order, it appears that one more person has been arrested.
Yes, and that will reveal from the next part of the CD, my lord, because it is to February. After their arrest, my lord, it is
When
silent.
will you have that CD?
Before we'll try, my lord, to bring that, my lord.
Monday,
or can it be on Tuesday?
Tuesday. Then let the 3 matters come up on Tuesday.
It comes, I can assist on that point.
One more submission, Lordship, regarding Lordship, they said Lordship 489C. Lordship 489C and 489B will not applicable against this petitioner, Lordship. It is specifically recovered from a Fazlul, Lordship. That was recovered from me. Otherwise, Lordship, this case is a 60 days office. It's a 60 days office.
You see, Mr. Counsel, very specific query is put to you. Substantial time has been gone.
Yes.
They have also been in custody for a long time by now. Now, appears that there are materials against them, implicating them in the offence alleged. But that alone cannot be a ground to not grant bail, right? So you address on that. If their further detention is not required, then this court will grant them bail. You get that instruction. These 3 matters. Item number 2, item number 36, and 55. For up-to-date case diary, list on Tuesday. Tuesday, date to be done.
My lord, 9th, my lord.
9th.
Here, Your Lordship, on the last occasion the CD was called for.
CD has come, my lord.
The FIR is at page 12.
Offence is under 489, 471-409.
No, sir, Lordship, 409.
Yes.
420.
FIR page
page
12.
12.
Page?
12.
Yes, relevant.
In the FIR, my name is not there. But
Relevant is 16.
Relevant is 16.
Yes,
Lordship,
please read.
Page 19, if your Lordship sees, my Lord, after investigation, what is the part, my Lord, then your Lordship will be clear, I suppose, my Lord. Page,
Yes.
Page 19, my Lord, ground of arrest, my
Yes.
Lord. All the details of
This
investigation.
is how land grabbing.
Yes, my Lord, land grabbing, my Lord. If your Lordship sees the first paragraph, my Lord.
Yes.
Yes.
Mr. Datta, you please.
Yes.
Mr. Datta, you can read page 19.
19.
Ground of arrest.
Ground of arrest, my Lord.
During the course of investigation, it is found that 2 plots of land measuring 2 cutters 4 laths covered by Dag number so and so of village Shahar Sharania, second part Maujar Ulubadi in the district of Kamrup, Assam, were registered in the name of Jakir Oja, son of so and so. And my lord, the sale deed bearing number.
You are for Jakir Oja? No.
No, I am for Sharifuddin. He happens to be the LDA of the registration office, my lord, at that relevant time, which were shown sold by late Dharmakanta Dekha on 7/9/2005 and 28/4/2006 respectively, whereas Dharmakanta
Which is the part which concerns the
yes, my lord,
Petitioner?
that your
Lordship
lordship
will see
middle of the
middle Lordship, my Lord.
if your lordship look at, whereas Govinda Kumar Barman died on such and such, another power of attorney, your lordship may skip that also. However, the aforesaid deeds were registered. Has your lordship got
Yes,
that?
yes.
However, the aforesaid deeds were registered at the office of the sub-register Panikhati. It is also verified that all the aforesaid sale deeds were registered at the office of the sub-register Panikhati only without securing the presence of landlord, Patta, that being the seller. However, during custodial interrogation, the accused Jakir Oja had admitted that during the time of registration of the aforesaid sale deeds, he himself went to the office and paid an amount of rupees 30,000 to the below mentioned accused Sharifuddin Ahmed, who was the then senior assistant, my lord, it ought to have been LDA of the office for registration of the sale deeds, and accordingly the sale deeds were got registered. During interrogation, the below mentioned accused has admitted that he and the then sub-register had done the said registration without following the due procedure, taking some money from the arrested.
Here the allegations are as regards the sub-registrar.
Yes.
Not the petitioner. Petitioner is not the sub-registrar, he is an LDA.
I am LDA.
He is LDA.
I retired as my lord, a senior assistant, my lord. At the relevant time I was LDA.
There doesn't seem any.
No, my lord. Here it says that he, Sharifuddin, my lord, take money from this, from the other co-accused persons for doing the
Where is
registration.
his name?
Sharifuddin, my lord. The below, if your lordship sees, my lord. However, during custodial interrogation, accused Jakir Uza, my lord, who is the land grabber, had admitted that during the time of registration of the sale deed, he himself went to the office and paid an amount
To
of rupees
Sharifuddin
to
Ahmed.
below Sharifuddin Ahmed, my lord.
Who was the then senior assistant of the office.
Office, my lord.
And accordingly, the sale deed was registered.
Yes.
So he helped the registration,
registration
of the forged sale
deed,
deed.
my lord.
How much days?
Only yes. Yeah, on 8/3.
8/3 he was arrested.
24 he was arrested, my lord.
And so how many days?
From
About
24 days.
About 24.
Lord, so far the custodial interrogation is concerned, my lord, I think is all over. And if your lordship look at,
since
The allegations are strong. He is an office. He is a
It's a
senior assistant
Yes,
of
very-
the concerned sub register office. And
At
there
this
are
stage-
allegations,
at this
and these are offences which are going on in a rampant manner.
yes, that your lordship is very correct. But at
These
the
are
relevant
not
time he was LDA, my
offences
lord.
to be.
Is a persons who
Yes,
are,
what is
my
the
lord,
status of investigation?
my lord, now, my lord, some documents were seized and some were from the circle office it was sent to DC office, my lord. From there it has to be seized, my lord. So it's a very nascent stage, my lord.
So
some
investigation is at an active stage.
Active stage is required for
Detention is required to unearth the truth.
Yes, my lord. It is required
Can I
because
take to your lordships one order dated 11/3/2024 passed by your lordships, where it has been stated that so far the necessary papers, these are all has been seized in the meantime.
In this
now,
matter?
my lord,
in this matter?
My lord, similar other matters connected with this case, Anup Ojha versus State of Assam, my lord. I will just share with your lordship that.
Yes, I believe if I recollect correctly, at that stage there was that the CD reveals that this petitioner was absconding.
Yes. My lord, now he is arrested.
Isn't it?
He is arrested.
No. Mr. Anup Ojha, my lord. I was never absconding, my lord. His Anup Ojha was absconding. And this is the, my lord, the petitioner.
Pre-and petitioner number 1.
From the last note, what it reveals, my lord, details of the.
In fact, the petitioner appears to have helped the accused persons in registering. That is the allegation.
That is the only allegation. And your lordship will find that title suit filed in regard to this land, the suit has been dismissed in the meantime.
Here also the bail application was rejected.
Yes, it was. I am just showing that Anup Ojha, he came before your lordship, who was the absconder, my lord. Not me.
Yes, but you see, your active participation materials are there. All right. Anything else?
My lord, that is so far merit of the case, my lord. If the
Anything else?
interrogation is all over, my lord, what happened in this case, my
You
lord?
heard the APP. According to the APP, investigation is at a very active stage.
But only
This is
thing,
the
my lord,
submission
if
of
your
the-
lordship is kind enough to consider.
And earlier also anticipatory bail to other accused
This is
was
the prime
rejected
accused, my lord. They are the kingpin.
with help of the petitioner. Yes. Anything else?
My lord, only thing if your lordship kind enough to consider, his wife is a cancer patient and he is required to escort her to
All right.
Chennai for treatment.
Item number 37.
Item number 37, lord.
Heard Mr. Sisi Datta, learned senior counsel, assisted by Mr. S. Datta, learned counsel for the petitioner. Stop. Also heard Mr. NP. M for Madhya Pradesh.
Mumbai.
MP Goswami, learned APP for the state respondent. Stop. This is an application under section 439 of the CRPC for grant of bail to the petitioner I. Sarifuddin Ahmed, who has been arrested on 8/3/2024 in connection with Crime Branch PS case number 3 of 2024, registered under sections 120B, 420, 468, 471, 409, 419 of IPC. Stop. The facts of the case is that in order to probably it's the same facts as recorded in Anup.
He used to help those persons
Yes.
with preparing the cell deeds, my lord.
Then you say Mr. S. Datta, Leonard Senior Counsel, submits that the petitioner who was working as the senior assistant,
Senior
assistant, he was LD.
who was working as LDA,
Law Divisional Assistant.
LDA at the relevant time in the office of the concerned sub-registrar, has been unnecessarily robed in the matter. Stop. He further submits that the petitioner has been languishing in jail since last 24 days. Stop. Mr. Goswami, Leonard APP, on the other hand, strongly opposes the prayer for bail. Stop. He submits that there are sufficient materials available on record implicating the petitioner for the offence alleged. Stop. He further submits that it is the petitioner who had registered the alleged forced sale deed.
Sale deeds, my lord.
Sale deeds. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. ইয়াৰ পৰা মই মাৰ্ক কৰি দিছোঁ পেজ 6ত আছে টিক মাৰ্ক কৰি দিছোঁ আপুনি এই গোটেইখিনি ইয়াৰ পৰা দি দিব তাৰ পিছত লিখিব thus the element of criminality is prima facie evident it is imperative to unearth the truth it appears that further detention of the petitioner is required to unearth the entire nexus of forgery by which the land was grabbed. As such, the bail application at this stage stands dismissed. Sorry.
Obliged. Much obliged.
Please, Lordship, we are supposed to file an affidavit in this case.
One second, Mr. Jutia.
We require 4 weeks time.
Disposed of, huh? Yes.
We are supposed to file an affidavit, my lord.
In 38?
There's an order. Yeah, 38, my lord. We require more 4 weeks time, my lord, to file affidavit.
There's a contempt matter. Yes. Yes, what is the instruction that required? What was not complied? Where is the order?
No, my lord. Actually, my lord, whatever lordship, kindly see the order, last order, my lord, was 16 to 2024, my lord.
16? Yes.
During the course of hearing, D. Soikyara, Learned Senior Counsel, appearing on behalf of the respondent, submitted that land in question fall within
whether the state government would require the land of the petitioner and also take into consideration the building which stood prior to demolition. That is the instruction we were required
to take. Yes, that's the instruction is
all right. Mr. T.C. Shutia, Learned State Counsel, submits that the instruction called for by this court by order dated 16/2/2024 is yet to be received. Stop. He accordingly seeks some accommodation in the matter. Prayer is not opposed by the petitioner. Stop. List this matter.
Second week of May, my lord.
Not so much time.
Because there's a holiday there.
You file. It appears that on the last occasion, I-13/3/2024, time 2 weeks time had already been granted to the State Council for obtaining the aforesaid instructions. Stop. Considering the urgency in the matter, further 2 weeks time is given. It is expected that by the next date the necessary affidavit is filed in the matter. Stop. List on after 2 weeks date did you?
Please, madam. Lordship, 18th is the reopening, Lordship. Maybe 25th.
Because you see, this is a 2014 matter. You have to
exactly,
understand the
urgency. We have to
urgency.
take clarification from another department.
All right. When do you want it?
25th, Lordship.
Not 25th. 25th is too late.
23rd.
Why is this for order?
The petitioner, my lord, the due amount is, my lord, bill amount 6,89,239, my lord. Already, my lord, proposal has been placed to the government for financial approval on 12/3/2024, my lord. So, some time maybe they received the instruction on 1st of April 2024.
Yes, you were required to that some instruction had already been kept on record.
My lord.
But you were required to update as to the present status of the entitlement of the petitioner. Ms. Das?
My lord. 1st of April, my lord, as per my lord, 1st April's instruction, my lord, That proposal has been already placed, my lord, regarding amounting to rupees 6
Taking
lakhs.
into account the above, list the matter again on 3/4/24, on which date Mrs. S. Borwal and its standing counsel shall update as to the present status of the entitlement of the petitioner.
My lord,
Yes.
entitlement is, my lord, 6 lakhs 89,200.
You have that?
My lord, this lordship copy is there.
What is this writ petition about?
Regarding transportation charges.
Regarding transportation charges. So this is now admitted.
Lordship, that amount, my lord.
6 lakhs
6 lakhs 89,000 amount.
is admitted.
Lordship.
But when can this payment be made?
Place has been, my lord, the proposal has been placed, my lord, before the government for 12/3/2024, my lord. So some time may be granted, my lord. That later it reflects the proposal's date, my lord.
You have received a copy of the instructions. You
My lord,
and in the meantime, anybody from finance is appearing. Because next time you will say that finance is not doing. It's a old matter, 2015.
Lordship. No.
Mr. Nath, this is a 2015 matter where the last instruction appears that a sum of amount of rupees 6,89,239 has been finalized, and accordingly a proposal has been sent to the government for financial approval. So thereafter, who has to pursue this matter, because this court is only concerned about the payment. So who is the authority whose presence is required for an effective
for the Food and Civil Supply Department? They will take up for financial approval with the finance lab. Ultimately,
So
after
is the finance anybody required in this matter? Mr. Borpujari, you are for finance. You see, because why I am asking for finance is because it is often noticed that the finance comes and says that they have not received the proposal, and unless finance is there, the state government says we have sent it to finance, but that does not address the grievance of the petitioner. The petitioner is now that the government has taken a stand that the petitioner is entitled to an X amount, this court is only concerned when this amount is going to be disbursed to the petitioner, especially when this payment has been denied to the petitioner since 2015.
Now, in a given situation where the state authorities might not admit the claim of the
amount to admit
petitioner, he is entitled to a specific sum of amount. So that extent might not apply approval, then within the administrative department consult, and thereafter, my lord, if there is any scarcity of funds or making any supplementary demand budget, then the matter is referred to finance department to the budget section. It is only at that stage, my lord, that the role of finance departments comes in, my lord. Otherwise, my lord, it is totally within the domain of the administrative department.
yes, Lord. Possibly.
When will this payment be made? That is only this court is concerned. Then you file an affidavit. Instruction has been given. You place the instruction by way of an affidavit indicating a time frame within which this amount can be paid. Alright?
Yes,
I'll record your name, Mr. Nath.
Yes.
Mr. D. Nath, learned senior government advocate, has submitted the instruction received by his office dated 1/4/2024, which indicates that a sum of rupees 6,89,239 has been allotted, has been sanctioned. Has been sanctioned?
Letter, my lord.
Has been allotted in respect of the petitioner. Stop.
Proposal.
Don't say stop. And accordingly, the same has been placed before the government for financial approval
in the department.
By letter dated 12/3/2024. Stop. Considering the fact that the payment as regards the transportation charges is pending since 2010, comma, it is desired that the state government file an affidavit placing the aforesaid instructions on record and also indicate positively a time frame within which the admitted amount is disbursed to the petitioner. Stop. Let this affidavit be filed within a period of 1 week from today. Stop. List this matter, reopening or deduct. 22 4/24.
Instruction.
A copy. Can I get a copy? All right. A copy of the instruction is returned back.
This is a land acquisition matter, Lordship. In this case, Lordship has appeared, being senior, Lordship has appeared in this
list before any other bench.
But date kindly be fixed, Lordship. Otherwise, it will be difficult because 2015 matter.
It's all right. If this court cannot appear, how can the court fix a date, Mr. Counsel? Please be mindful of what you are submitting. Yes. Okay. Contempt.
Yes. So it's a contempt matter. The direction is to furnish the certified copy of the some voter list to the petitioner. I appear for the respondent who was an election officer in 2020. He got transferred in 2020. Thereafter, he is not in a position to apprise. But he, at that point of time, he informed me.
What is the direction which has not been complied?
The certified copy of the voter list is to be provided to the petitioner.
Okay.
But that application was at that point of time rejected because D mark was given in the voters list, doubtful, D. The Honorable Court has directed to provide the certified copy. The officer concerned for whom, the election officer for whom I am appearing, he got transferred in 2020.
The new incumbent is not made a party?
Not made a party.
Within a week.
You plead?
Yes. Within a week.
List this matter after 1 week to enable the petitioner to make necessary arrangement to file appropriate application to bring on record the present incumbent to the post of
election officer.
Election officer?
No.
List after 1 week?
2 weeks.
After 2 weeks and a date to be fixed by the registrar.
These matters are becoming infructuous.
May I please, Lordship? Lordship, we filed an affidavit in reply, Lordship. Some time may be given.
This has become infructuous. The contract period is already over.
You have filed an affidavit in reply? When?
Lordship, after this, Lordship.
Mr. Counsel, you are seeking time to file an affidavit in reply or you have filed an affidavit in reply?
We filed an...
You filed?
No, they have not filed.
Then ask for time for filing. Then why are you saying that you have filed?
Lordship peruses the
21.
NIT the period of contract is already over.
But if the petitioner is not agreeing with your submission, what can this court do? Then this court will have to hear the matter. He is seeking time to file and reply to the affidavit that you have filed.
I understand.
How can the court not grant that prayer? It is your name.
M. Hussain.
Mr. M. Hussain, Learned Counsel, for the petitioner seeks 2 weeks time to file affidavit in reply against the affidavit in opposition filed by the railways. Stop. Prayer allowed. List this matter after 2 weeks and a date to be fixed by the registry.
Natural.
44 to 43 lagat nahi jano. 43, 44 is same, huh?
May I please, Lordship?
Lordship, here, Lordship, this IA, Lordship, is for
amendment?
Yes, Lordship.
Amendment of what?
Amendment, Lordship, there is three purpose, Lordship. I have stated in paragraph 345, Lordship.
Paragraph?
345, Lordship. In 3 level, I have stated, Lordship, 2 persons have to be added, Lordship, 2 officer, Lordship.
Implement or what?
Implement, Lordship. And in paragraph 2, Lordship, I have stated, Lordship, the implement of paragraph 30 should be deleted,
Sir,
Lordship.
Counsel, this application is for implement or amendment?
Amendment, Lordship. Actually,
amendment of what?
Amendment of, Lordship, paragraph 30 should be deleted, Lordship, and in addition, Lordship, this paragraph 30A, B,
has to
and
be
C.
added.
Yes, should be added, Lordship. There is some, Lordship, some lessons, Lordship, there, Lordship.
There has been some typographical errors.
Yes, so details was not there, Lordship. So details I have given here, Lordship. It is regarding, Lordship, the birth and death registers authority is there, Lordship. Their involvement is there, Lordship.
You see, at page 16, you are saying addition of the following officials as party respondents.
This is also there, Lordship. Actually, this should
But
be.
you are not pressing this.
This is also needed,
Because
Lordship.
this you cannot bring by way of an amendment. If you want to add some officers, you will have to file an appropriate implement
Yes, that is another
application.
part should be there, Lordship. I have made in one petition, Lordship. So when this paragraph, Lordship, 30 ABC will be added, then, Lordship, that these 2 persons will be necessary, Lordship, in the writ petition, Lordship. That's why, Lordship, there also I want to add them, Lordship.
There are certain procedures, you have to follow the procedures.
Lordship, first part, then, Lordship, paragraph 2, Lordship, this may be added, Lordship. And, Lordship, another part, Lordship, I have issued paragraph 4, Lordship. There is also, Lordship, some 2 annexer only. This 2 annexer is misplaced, Lordship, because there is various documents, Lordship. So, even I have submitted the correct documents here, Lordship. I am.
1 second, Mr. Counsel.
Lordship.
Why don't you withdraw this writ petition and you file a fresh writ petition? That will serve your purpose. You are saying there are 2 annexures which has been inadvertently not brought on record. You are saying 2 persons needs to be implemented. 1 paragraph has to be completely changed. You withdraw and file a new writ petition.
Lordship, it will be difficult, Lordship.
What is the difficulty when you are filing the IAs? Yes, Ms. Das?
My lord, because it will, again it will change probably, various, color of the, because they are now implementing.
I think that would be appropriate for you.
Yes,
We are not going into the main issue. You want also directions for correcting the annexures. 2 annexures has been mistakenly crept in, you are saying.
Yes, Lordship, yes.
You withdraw and you file a new fresh writ petition. We'll give you the liberty.
If register of birth and death is there, so
that would be more appropriate.
Yes.
How can
In case, Lordship, again, some delay part will be there, Lordship.
Then it was for you to, at the first instance, to do what is appropriate. How can you file an amended an application seeking amendment of impleading parties, removing 2 annexures?
Yes, Lordship.
Can that be granted in an amendment application? How can the annexures be removed from the record?
Implement of the 2 persons, Lordship, I will file a fresh petition, Lordship.
Removing cannot be.
You see, your prayer for removing 2 annexures cannot be granted in this application. That cannot be granted.
And now regarding delay, interlocutory episode 2022, now he is pressing it up 24, he can file within 1 month or 2 weeks.
It was filed earlier.
OA, writ petition, fresh writ petition, he can file it, because otherwise, everything will be changed because...
What is this paragraph that he wants to bring in? Paragraph 30?
30A.
There should be some details, Lordship, in the writ petition page 25, Lordship.
Do you have any objection to that part of the petition?
Lordship, because now he wants to, of course, because he wants to bring that regarding allegation against
main part, Lordship.
register of birth and date, and who was not earlier in the petition, he was not party. Now he is bringing some allegation.
Now, why I am bringing them, Lordship? Because while this part will come, Lordship, because
were these things not available with you when you had filed the writ petition?
Lordship,
were these materials not available before you when you had filed the writ petition?
No, Lordship. While this
where have you said that in this application?
I have not stated
Then-
but Lordship, but
then
the
You are
issue is here,
seeking for
Lordship.
an amendment. Amendments of a
birth
repetition
certificate
cannot be
issue-
granted in a routine manner.
In the-
You have to make out a case.
In the
Correct?
first part, Lordship, while in the first time, Lordship, I have no instruction that the issue is the pending before them, birth certificate issue is there, Lordship. But later I come to let that.
Where have you stated that? Where have you stated that in your amendment application?
I have not stated
Then
it.
how do you expect this court to proceed in the matter in a routine manner? Merely because you are seeking for an amendment without any application of judicial mind, you want this court to pass an order? You have to make out a case.
The paragraph 30, this amendment will be granted, Lordship, and for the added Lordship, then I will file a fresh petition, Lordship, for implement, Lordship.
It is very difficult when councils do not try and understand what the question that is being posed. You see, for making an amendment, you have to make out a case, correct?
Yes, of course.
Now you are saying that you have not made any averments to the effect that you are submitting now, that you didn't know about these facts.
No,
Where are those averments?
This is not correct, my lord. In that page 16, my lord, that the Roman 2, my lord, middle portion of 30A, they applied for permission for delayed death registration before the Deputy Commissioner
2017.
Durham.
2017.
My lord, 17. This petitioners are granted the permission for delayed death certification in the month of February 2017.
So why
by the
have
office
you then not put this in while you had filed
What
the
the details
petition?
was not there, Lordship. Now I have given the detailed description, Lordship. This is the Lordship difference.
Because we have filed the affidavit on my lord in 17 to 2022.
Government has filed affidavit in
My
this
lord,
matter?
affidavit has been filed.
When have you filed?
My lord, date of swearing is my lord 17 to 2022. My lord,
17?
17 to 17 February 2022. They are in the my lord,
And the IA is filed when?
date my lord.
After the reply.
11/7/2020. Receipt. Sorry, 11/1. My lord. Prior.
11/1/22 before.
2020.
Before Lordship. So Lordship, when it is allowed, Lordship, their affidavit also, Lordship, say they may well change their affidavit, Lordship. Also the vital, the main issue is the different, Lordship. Only I am saying that in the requisition, the requirement of the Lordship, that now we need the birth certificate, Lordship, to collect the birth certificate. Sorry, date certificate, Lordship. And date certificate, Lordship.
Anything
issue,
else?
Lordship, in the issue, Lordship.
Very well. I'm sorry, this court will dismiss this IA.
No, Lordship, dismiss Lordship, then Lordship, if they have to file any objection, Lordship, they may file Lordship, and Lordship, I will.
You are Mr. S. Hawk?
Yeah, I will certify Lordship.
Heard Mr. S. Hawk, Learned Counsel for the petitioner. Stop. Also heard MSU Das, Learned Government Advocate, Learned Additional Senior Government Advocate.
My lord.
For state respondents.
My lord.
Lordship, that kindly then maybe take another day, Lordship. I will certify Lordship. I will certify Lordship with some.
This is an application filed by the applicants for amendment of the connected writ petition IWPC number 5635 of 2021. Stop.
All Lordship, then Lordship, I may be allowed to do this. I Lordship, I will to file a fresh Lordship. I may be allowed to do this. I Lordship, I will file a fresh Lordship.
Mr. S. Hogg, Learned Counsel for the petitioner, submits that he has instructions not to press this IA Civil 177 of 2022. Stop. In view of the aforesaid endorsement, the interlocutory application for amendment stands disposed of on withdrawal. Stop. Before that you say with liberty to file afresh, and then say disposed of on withdrawal with liberty.
Obliged.
Lordship, 46 is the contemplation, Lordship, and 47 is the main declaration, Lordship.
46 is contempt.
Contempt, Lordship, yes, Lordship.
Yes, government.
Yeah, Lordship, order was violated, Lordship. All Lordship cannot be, Lordship, fixed for admission, Lordship, for final disposal, Lordship.
Well, it was against an interim order. In the main case, affidavit has been filed. Main case, the item number 47, that can be taken up, my lord.
47.
Taken up, then maybe fixed for a lordship, the admission column lordship, then have to some reversion lordship in the main case lordship.
Surveys and everything is ready.
Affidavit has been filed.
Why the matter was posted for orders today?
Well, the contempt case is tagged, that is one.
Contempt cases?
Contempt case is tagged, that is one.
In the contempt, you are not filing a reply?
Well, in the contempt, in fact, it's an affidavit in the person concerned. Person concerned is no longer there. I have the instruction that
there is change in the post.
Logic.
The new incumbent is not a party.
Here in the contempt case, no, Lord.
Yes.
I don't know lordship. I have no knowledge.
The senior government advocate is making a submission, so you take your instructions, and if there is change in the contempt, you make necessary applications. Yes, Mr. Nath, you want to say something?
Otherwise, I have the instructions that there is no violation. Lord. I'll place it.
No, there is a clear violation.
What is the violation that has been complained of?
I'll place it.
Mr. Nath, what is the violation that has been complained?
Well, there is a direction that they will not be evicted, Lord.
Not evicted.
From that place.
Thereafter, where some step, something has happened? And
no, madam. No,
violations?
My instruction says.
Lordship, violation is the lordship. First, read court or first in the read petition order was the lordship. They without followed by any procedure, there should not be any eviction lordship. But when they submitted the order lordship on the day itself, lordship, they evicted lordship. They evicted on the day itself.
No,
yes, lordship, evicted.
Not from that.
Again, lordship, we file another petition, lordship.
Mr. Nath, you see, even if there is a change in the pose, the person that you are representing has to also clarify his stand, because it's a contempt petition. Correct?
Lordship.
So you file your affidavit.
And another violation,
Lordship.
Yes, in the contempt petition for exponent number 1, I have, circle officer, I have filed my affidavit here.
You have already filed?
Yes, Lordship.
And who is the person who is now changed? Circle officer.
Deputy Commissioner, respondent number 3, for whom I am appearing.
Number 3?
Number 3.
And 1 has filed affidavit?
1 has filed.
2, what about the subdivision officer?
I don't know whether he is there or not.
Mr. D. Nath, learned senior government advocate appearing on behalf of respondent number 3, has submitted that in the meantime, a new incumbent has joined the post of the Deputy Commissioner Revenue Branch Kamrup at Amingao. Stop. In view of the aforesaid submission, Mr. S. Hawk, Learned Counsel for the petitioner, seeks some time to verify, 1 week time to verify the same and obtain instruction in the matter. Stop. List the matter after 1 week on a date to be fixed by the registrar.
In the main writ petition, we have filed the affidavit. There we have said that there is no eviction. And in fact, from the PWD roadside only,
so the main petition can be posted for admission?
Lordship, along with that.
In item number 47, list this writ petition for admission.
Madam.
May it please the Lordship. It's an admitted amount of contractual bills. On the last occasion, the Lordship directed to file them an affidavit.
And I have received the instruction, my lord. For
Why
this,
affidavit is not filed?
my lord, in fact, it is the disbursement was under process, my lord. It was sanctioned by the finance department, but it is due to some technical issues, my lord. Ceiling cannot be uploaded in the finance portal by the directorate, my lord.
So what is to be done?
Now, my lord, again we have to resubmit for sanction, my lord, because this financial year has been over, my lord. So
when it is due from when?
Your Lordship, the contractual works over in 2013.
2013?
And this contempt petition was filed in 2022, Your Lordship.
It is long due?
Yes, my lord.
Your Lordship, may I make a submission, Your Lordship? That was the submission precisely I made. They are trying to take a grudge against the petitioner because he has approached this honorable court. Why that delay has been done, Your Lordship? To release it. Unnecessary formalities have been created.
No, there was no unnecessary formalities because
yes, Your Lordship. Your Lordship, the order is at page 102, Your Lordship. I'm sorry, Your Lordship, 101, paragraph 9.
Paragraph
9. May I read, Your Lordship?
Yes.
It is seen that the dues of the petitioners are clearly admitted by the department in their affidavit filed on 8/4/2021. The claims made by the petitioner in respect of the goods supplied and the bills pending have not been disputed. Under the circumstances, this court is of the view that the writ petition can be disposed of with the direction to the respondent secondary education department to examine the claims of the petitioners in respect of the goods stated to have been supplied to the erstwhile director of madrasa and the bills pending for the release, and thereupon specific proposals be forwarded to the government seeking funds as may be required for payment of the bills in respect of the petitioners. While preparing the proposal, the department is at liberty to seek any further information required from the petitioners, if necessary, in respect of the bills which are categorically admitted by the department. The proposal is directed to be prepared expeditiously and forwarded to the finance department for sanction of the required fund. Such exercise is directed to be completed within 2 months, which they have not done, Your Lordship.
And this order is dated?
This order was dated on 30/10/2021, Your Lordship.
Since 2021, this matter is pending.
Your Lordship, thereafter I
Have you
communicated.
filed any affidavit?
No, well, affidavit, we have not filed any affidavit because well, there was some examination in the part of the department. Well, they've examined the bill and finally it was found to be correct. Then proposal was sent to the finance department. Finance department
This court is not granted with all these shifting of files from one place to the other. The court has given us positive order in favor of the petitioner. You still say that there is no dispute to the amount. In that case, this court does not understand as why the bills of the petitioner shall be kept pending for so many years.
Well, in between,
This is a bill pertaining to 21.
No, these bills are of 2013.
2013. How can the bills not be attended to? Whatever requirements you have, whatever sanction, whatever forms, sort it out and you disburse the
finance
amount.
department has already, after views
And
of
you are
the
not even filing any affidavit.
judicial department, my lord. In fact, in the latest instruction, it has been mentioned that there was a query from the judicial department.
This court is not concerned with all these queries and all that thing. These are things which you have to sort it out.
Yes,
You
we
see,
have
a
sorted.
litigant,
We have sorted out, my lord,
Yes.
and then finance department sanctioned the amount.
there is a positive order in favor of
Yes,
the
yes, my lord. We are not disputing
correct?
that, my lord.
To
In fact-
examine, which you have done,
Yes, my lord.
and you have found that the petitioner
Yes,
is
my lord.
entitled.
Yes, my lord.
Thereafter, what is to be done?
Thereafter, my lord, we have sent the proposal to the finance department.
When did you send it?
In fact, in the instruction, it has been written, my lord.
When was it sent?
My lord, query was raised, my lord.
Not query. You see, a contempt petition has been filed. You must file an affidavit to show what you have been doing. How can this court examine the matter on the basis of one page? We have to see that you are pursuing the matter in a bona fide manner,
Yes, yes,
correct?
my lord.
That is what also has to be seen.
Yes, my lord.
How do this court ascertain that part? Unless an
That-
affidavit is being
that I
filed,
can- that I can
unless you
bring-
explain what you have been doing.
That I can
When
bring it on
the,
record.
when you made the examination, what happened after the examination, on which date these
Yes, sir,
queries
that I
were
can
asked,
bring it on
everything
record,
must
madam.
be on record.
Because since it is
And finally, you must come up with a time frame within which the payment has to be paid.
Yes, my lord.
You filed that affidavit
Yes,
Monday.
Yes, sir.
Enough time has gone. Mr.
NJ Khatoni, my lord.
NJ.
Yes, ma'am.
Mr. NJ Khatonia, Learned Standing Counsel?
Well, I'm appearing as a
appearing for the contempt
contempt
matter.
matter.
Learned Counsel for the respondents submits that he has received an instruction dated 28/3/2024 in the matter, whereby it appears that the proposal for releasing the amount in due to the petitioner was not submitted in the correct form. Stop. Be that as it may, it appears that the bills of the petitioner pertaining to the year 2013 for the work completed satisfactorily by the petitioner is pending, despite of the order of this court by order dated 27/10/2021 to examine the claims of the petitioner and release the same within a period of 2 months. Stop. It is unfortunate that till date no affidavit has been filed by the respondents indicating the stand of the respondents in the matter. Stop. By way of a last chance, the respondents are given time to file an affidavit placing their stand in the matter and specifically indicate the time frame within which the admitted contractual amount, within which the contractual bill amount shall be disbursed to the petitioner. Stop. List this matter on Tuesday.
Lordship, here, if I can make a submission, Lordship, I am appearing for respondent number 2 in this matter, my Lordship. He is no longer holding the post. Whenever the finance department has been given, we have already sanctioned that the amount which they have. So finance department has never hindered the process, my Lord. The payment has to be made by the education department. So since he is not holding a post, my Lord, finance department be exempted from filing an affidavit at this stage because
affidavit. You are saying affidavit.
I filed for the respondent number 3, my Lord.
Respondent number 3.
All throughout, Your Lordship, this person was holding the post, so he requests to file an affidavit.
No, we are not getting into all that. You see, but if for some reason this person is at this present not there, then in order to get an effective order, you will have to impeach the new incumbent. You get that done. Otherwise, you will have difficulty. List on, yes. A copy of the instruction dated 28/3/24 is kept on record.
Tuesday, Lord. Or on 9th, Your Lordship.
File it by then.
Yes, my Lord.
Yes, Mr. Charlie.
Lordship, item 16 was item possible for the timing by the counsel for the petitioner. Lordship, I have got some difficulty in the second half. Can it be taken after vacation, Lordship?
All right. Item number? As prayed for by the learned counsels appearing in the matter, list this matter
25th
on
5th
25/4/2024.
Interim may continue.
Interim, if any.
Lordship,
Yes.
Lordship, we have received information that an amount of rupees 1,70,6,842 has been paid to the condemned petitioner, Lordship. Lordship, we need some 2 weeks time to file.
Where is the petitioner? According to you, the payment has been made.
Yes, Lordship.
Service report. Await service report in respect of respondent 1.
Lordship, I am not. Respondent number 1 will be the Commissioner and Secretary Handloom. She is representing respondent number 3. One only.
You are appearing for 1.
Yes.
And for 2?
Lordship, I am appearing for 2.
So respondents, then service is completed.
Lordship, to a certain extent, because I think they have complied also substantially to the order in this file, the affidavit.
Who is for 3? Director Handloom.
Lordship, here, Lordship, as
Lordship, I'm for both 1 and 3, Handloom Department.
They can appear.
MS.
Tushisna, on behalf of Mr. Arda.
MS so-and-so, learned counsel for the learned counsel appearing for respondent number 1
and
3 is present. Mr.
A. Chalia, Lordship, for respondent number 2.
Mr. A. Chalia. Mr. A. Chalia, learned counsel for respondent number 2 is also present. Stop. On top you say none appeared for the petitioner when the matter is called. It appears that service in respect of all the respondents have already been completed. Stop. MS so-and-so, learned counsel for respondent number 1 and 3 submits that substantial amount in terms of the order dated 2/5/2023 has already been paid. Stop. Let the respondents file their respective affidavits in the matter. List after 3 weeks on a date to be fixed by the registrar. You file your affidavit, you bring that on record.
Has already been repealed, under which is my lord praying for my lord for registration of
Thus,
this
what has happened?
My lord, our case is like this, my lord. My wife filed, I am a CRPF person, my lord.
Your?
CRPF. My wife has filed 8 cases against me, making my life extremely miserable. I cannot do my duties. And there were also other bad qualities with her. So, there was a village meeting. Then you accept this, henceforth she will
Yes,
not.
on the last occasion, instruction was called from the Government Council as regards if any action has been taken on the application filed by the petitioner.
My lord, that
I am
is not
submitting,
there.
my lord.
One second,
but,
Mr.
but my
Ahmed.
lord, the act under which my lord this relief has been sought for, my lord, that has already been repealed, my lord. Hindu.
That has been?
Sorry, repealed, my lord. Muslim.
Repealed?
Repealed, my lord. That ordinance is there, my lord. Ordinance, my
What have you sought in this petition, Mr. Mahmood, in the
My lord,
petition?
as per the Muslim Marriage and Divorce Act, that is 1935, Section 9 is there, Lordship.
Yes.
Section 9 says, on application being made to a Muslim registrar for registration under the Act of a marriage of divorce within 1 month of marriage of divorce being effected and not otherwise, and on payment to him of a fee prescribed as per Schedule
So here,
4.
that after being the steps under Section 9 was not taken.
No action was taken.
No
What my
action.
learned friend is saying
Is now
that
repealed.
it is not repealed with effect from 16/4 to 24, madam. But my case, I have filed petition on 24/6/23.
So this is prospective.
No, it is prospective, yes, not transportive. So, my case still exists.
Yes, it is prospective. There is a saving, notwithstanding such repeal of the Act as mentioned in subsection 1 above, anything done or any action taken under the Act so repealed before the date of commencement of this so-and-so shall be deemed to have been validly done or taken under the repealed Act.
Yes. And leave that to section 2
Now,
also.
my lord.
Yes, but what about the instruction
The
that was
instruction,
asked?
my lord, instruction has been sought, my lord, but that we have not received, my lord.
Mr. Mahmood, there is a judicial order by which the government advocate was asked to find out what is this action that they have taken on your application. Let them get that instruction and file an affidavit. But Ms. Das, this is the last chance we are giving you.
Lordship,
You
because
cannot, because we've been noticing, this court is noticing since morning that in various matters, despite so much of time being given, instructions are not coming forth, affidavits are not filed by the department.
My
How
lord,
will
two
this
letters,
court
my lord.
proceed
Lordship,
if
two
the
letters have been
government
received.
does not cooperate? These
Lordship.
instructions and affidavits must come.
Lordship.
May be kept as part heard, madam.
No, what part heard? We have not heard you, Mr. Mahmood. MS Yudas Larat, additional senior government advocate for the state for Assam, seeks further time to place the instruction as called for by this court. We ordered it at 11/3/2024. Stop. Prayer is not opposed by the petitioner. List again on
9/4.
My lord,
9/4.
his prayer, main prayer, Lordship can be placed to
Ms. Das. There is an order of this court. Please comply with it.
Lordship.
When will you file your affidavit?
My lord, after 3 weeks, my lord. Because in between, my lord, Bihu Band is there, my lord.
But you give a date after the Bihu holidays.
My lord, maybe a longer date, my lord. My lord. Last
Pardon
part of due, last part of due.
But
Lordship.
34/2024.
Obliged.
Positively, huh? To file positively.
Lordship may kindly take up my applicant. You want to read petition?
What is this IA?
This is an application IA 542 of 24. This is filed by state. This is for early hearing. We have some early urgency.
My lord, we have no objection to that, but only, my lord, it may, if a date is fixed by your lordship, it
Can
will
it be
be in the
be,
month of May.
may I suggest,
By filing the instant interlocutory application, the state respondent seeks early hearing of the connected writ petition IWPC number 5946 of 2023. Stop. Mr. K. Mohammed, Learned Counsel, appearing for the petitioner stroke respondent, has no objection. Has no objection. Has no objection. Stop. In terms of the aforesaid concession between the parties, let this matter be listed for hearing on
22nd of April.
Not April, my lord. In the month
29th,
of
my lord.
In the month of May, my lord. My lord, first week of May, my lord.
My lord, what I am saying, Advocate General.
2nd of May.
My lord, Advocate General will be appearing in that case. On his behalf, I am making an.
Is 2nd May comfortable?
Can it be on 29th?
My lord, only 3 days, my lord. What difference will it make?
Is 2nd May comfortable to him? No. Comfortable? 2/5/2024.
Much obliged.
The I stands disposed of.
My lord, only in the order for petitioner and it should be opposite parties, my lord, instead of respondents.
Much obliged.
Petitioner stroke, petitioner stroke, opposite party. Mr. Chaudhary, this matter, otherwise I think hearing
Concluded.
Is concluded, right?
Yes,
this is that where Mr. Das.
He is another court, my
Yes,
lord.
he has already finished his
My lord.
argument. So we shall close the hearing and reserve it for judgment then. Hearing concluded, reserved for judgment.
Ask us.